Welcome to this webinar hosted by the Chartered Institute of Logistics and Transport, North America. Thank you for joining us today to this presentation that bears the title, When One is the New Zero, Carrier's Limitation of Liability. When does a carrier's limitation clause in fact result in full value liability? I am Eric Harvey, Senior Counsel Regulatory at CN, where I have been for nearly 15 years. For the benefit of those of you who are not aware of CILT, we are a professional body in the supply chain, logistics, and transport industry. With 34,000 members in over 30 countries, CILT's mission is to develop the art and science of logistics and transport through research, education, networking, and the sharing of ideas. Today, we have 180 registrations for this conference, with representatives from, I believe, 8 countries. Thank you all for joining us. I believe it is important to stress that the North American chapter of CILT gathers representatives from all sectors of the industry. Carriers, customers, shippers, infrastructure owners, engineers, consultants are all working together at the CILT to advance the cause of efficient logistics chains. This feature attracted me to become a member, and I'm glad to help the CILT today. I thank the organization for this invitation to act as moderator. First, I would like to share with you some housekeeping items. Everyone is muted with your video off. Please do not unmute or turn on your video, this to facilitate the flow of the bandwidth. Also, if for some reason the communication cuts during the presentation, please just join the meeting again and we'll all welcome you like we did at the beginning. We encourage any questions you would like to put to the speakers, and we have planned time at the end of the webinar for a Q&A panel. If you have a question, please use the Zoom chat feature during the webinar, and your questions will be answered after the presentation. The event is being recorded, and you will receive an email with the link to the webinar. After the webinar, we will also send all attendees a feedback survey. Please take a few minutes to complete it so we know what your thoughts are about the webinar. Your feedback ensures our webinars continue to serve you in getting the knowledge you need for your profession. Before I introduce our speakers, I would like to take a moment to thank our sponsor, Marsh Canada Limited. Marsh is a global leader in insurance broking and risk management. In more than 130 countries, their experts across many industries, including rail, help clients to better anticipate, quantify, more fully understand, and manage the range of risks they face. The question of liability is critical in any transportation contract and in any mode of transportation. The cases to be discussed today illustrate the importance of this aspect. We have 2 competent legal counsel to discuss this matter, David Blair and Brian Lipson from McCarthy's in Quebec City. David has practiced transportation law for his entire career and is leader of the Transportation and Logistics Practice Group at McCarthy Tétrault. Considered an authority on rail and road transportation law, David advises on cross-border and domestic M&A transactions involving transportation undertakings and appears regularly before the Canadian Transportation Agency on all matter of rail issues, as well as before provincial regulators in the highway transportation sector. He acts for 2 Class 1 railways and leading Canadian, US, and European companies in the rail, trucking, bus, and mining sectors, which routinely seek his advice. Brian Lipson is an associate in the Transportation and Logistics Group at McCarthy Tétrault. His practice focuses on mergers and acquisitions, regulatory compliance, and contracts, with a recent focus on tariffs and confidential contracts in the rail mode. Brian advises both railways and shippers on agreements and disputes related to railway safety, crossings, sidings, level of services, regulated interswitching, and accessibility complaints. He's a regular attendee of the CILTNA events in Ottawa. This is his first CILTNA conference as a speaker. I now turn to David for the beginning of this conference.
Thank you very much, Eric. Before beginning, I would like to also thank the CILT North America for having organized this excellent event and for all the events they do organize. Special thanks to Gilles Legault from CN, who planted the seed for this at the beginning, also to Eric Harvey from CN, and to Brian. And most of all, I'd like to thank you all for being here and attending this session, which is, at first glance, could be considered somewhat uninteresting, because we're looking at the carrier's capacity to limit or exclude liability in the case of loss or damage to goods, and how the carrier may limit or exclude its liability where it's responsible at law for the damages caused to the goods. So it might appear boring at first glance, but actually when you dig into the subject, it is quite fascinating. And some of us transportation lawyers think that follow it closely, and understand the depths to which you have to go to follow and understand the concept of limitation of liability. So a bit of history to begin with. We're going to, just to give you to describe what we're doing in this presentation, I'll be giving you a little bit of history of the background of limitation of liability, the responsibility of the carrier, and the concept of a common carrier. And I'll be looking at a recent case of the Quebec Appeal Court, where CN versus ACE, European Group and Insurance Company, involving a case involving CN and Bombardier. And Brian will be looking at a recent federal court decision, ABV versus CN and CSX. And following that, there'll be a question and answer period. I hope we'll have time to answer some questions. So to kick off, we have to look at what is a common carrier, the concept of a common carrier. So the concept of a common carrier is essentially, in the old days, it's a profession, a defined profession, and the obligation of the common carrier is to offer service, transportation service. It's essentially an open offer to provide service. And a common carrier cannot refuse service. It cannot choose to say, well, I'm not going to transport your goods today because I don't feel like it or because I'm busy doing. It has an obligation to provide this service to the shipping public. And it also has an obligation to carry the goods to destination in the sense of a strict obligation. So if we look at the obligation of a common carrier, the fundamental issue is one of, it has an obligation of result. The common carrier must deliver the goods to destination, as opposed to an obligation of means, where it must provide its best efforts to do so. And so in other spheres of activity, as long as a service provider can show that it provided its best efforts, it may be considered to have done what it had to do. Whereas a common carrier has to deliver their only, I've given you a list here on the screen of different defenses that can be brought up, the basic defenses of a carrier. And they are defined, they've been defined in common law, and they're also repeated in the Canada Transportation Act regulations. So act of God, war or insurrection, riot or strike or lockout, defect in the goods, act, negligence or omission of the shipper, authority of law, quarantine, or natural shrinkage. So if it's not one of those cases and the carrier is not able to get the goods to destination in whole, they are liable. They are responsible. It's a strict liability. And the history of that goes back to a very long time. The oldest case that I could come across goes back to 1343, where a horse was lost on a ferry that was overloaded, and the captain of the ferry was found liable because he put too much. There was too much weight on the ferry, which caused it to overturn, and the horse was lost. Later on, in the very beginning of the 18th century, the Lord Holt, Chief Justice of the King's Bench, was very influential. Two very influential cases, which sort of set the stage for this obligation of result and strict liability of the carrier. So the first one, which I refer to as Coggs versus Bernard, where Mr. Coggs was transporting a load of brandy in barrels belonging to Mr. Bernard between 2 points in London. I think to a wharf where it was being loaded onto a barge. One of the barrels dropped and staved, and 150 gallons of good brandy were lost. There was no contract. There was no payment for the movement. But the court, Lord Holt, went through what were the obligations of someone who had received the goods as a bailee of the goods, essentially. The court found that the goods were placed in the hands of the carrier in trust, and that the carrier had a liability to deliver them, and basically could not invoke the fact that there wasn't a contract or anything else, and that the carrier was liable for the loss. And in another case slightly earlier, the same Lord Holt made reference to this strict liability, and he said it's a hard thing to charge a carrier with strict liability, but he founded it on the fact that if there was not strict liability, the carrier could say, well, I brought my best efforts, I did everything I could, but I got robbed by thieves. It fell off the back of all kinds of excuses. And because the owner of the goods are not there to be able to prove the negligence of the carrier, the courts decided that from now on, the carrier is liable, absent those specific defenses that were invoked. So in Canada, we have this strict liability, obligation of result. Those are the two things that have been set up from common law in the history of cases. So in a commercial context, it is absolutely essential, it has been found to be essential between carriers and shippers to be able to limit the carrier's responsibility. Why? This is not simply a means for big, nasty railways to cause harm on poor little shippers. The purpose is to find a balance between who can best ensure the risk of carriage that is necessarily there in any transportation undertaking, and so it has been determined that, and commercially it is developed to this limitation of liability. So in the highway sector, which we're not going to look at today, but in the highway sector, typically there's a regime in Canada which was well applied, whereby carriers are liable up to $2 a pound based on the total weight of the shipment, and beyond that, they're not liable unless the shipper declared a higher value, in which case the carrier would charge a higher freight rate. Now, in the case of railways in Canada, we're going to look into detail in here. The railways are liable for the full value of the loss or damage to goods, unless stated by regulation or by agreement. And so if we look at what is the state of the regulation, what is the state of the law in Canada, and what are the instruments of the law, we have the Canada Transportation Act, which basically covers the federal railway system and regulates the operation of railways in Canada. And it regulates tariffs. It regulates at 113 the railway's obligation as a common carrier. It regulates the possibility for shippers and carriers to enter into confidential contracts which can establish conditions outside the published tariffs. And it recognizes the limitation of liability agreements need to be signed by the shipper. There's also the railway traffic liability regulation, which also establishes the regime to be applied in the case of loss or damage to goods absent an agreement. And then we have the Quebec Civil Code, which covers limitation of liability and the carrier obligation. We have the common law, and then we have and obviously contract law between parties is something that is under provincial jurisdiction. The railways are under federal jurisdiction, so one has to read and negotiate and figure out which section of which law applies in each case. So this is that is the background, and now we're going to look into specifically the decisions that we mentioned earlier. So the first one. And the first one I'm looking at today is the case of Canadian National Railway versus ACE European Group, which was the insurer of the goods shipped by Bombardier. It's a case from August 2019 of the Quebec Court of Appeal, Justice Marie-Josée Hogg, and it was on appeal from a Quebec Superior Court judgment of 2017. Leave to appeal to the Supreme Court was denied in May of 2020. So this is basically the law that this case will not be challenged and sets the stage. So let me give you a brief description of the parties. So the carrier is CN, which is a large Class 1 international railway, which we all know, headquartered in Montreal. The shipper was Bombardier, equally a well-known multinational transportation company, headquartered in Montreal, who manufacture, amongst other things, passenger rail cars. And the insurance, the defendant is, well, the defendant was Insurance, ACE Insurance Group, out of which was the insurer of Bombardier's shipment. So the facts in this case are as follows. Bombardier contracted to move 2 regional passenger rail cars from New York to La Porcatière for repair and maintenance, which was something that they did on a regular basis and something that the CN carried on a regular basis. So Bombardier was a frequent client. The parties agreed to a lower rate, with partly based on the fact that the cars were moved as part of a train consist. In other words, they were moving on their own wheels and not put on a flat car, on a CN freight flat car. And under the agreement, because they were on their own wheels, the agreement provided that there was a zero liability. However, if they'd been, their agreement also provided that if they had been on a flat car, the liability would have been limited to $25,000 maximum. Bombardier chose a cheaper rate to have them on their own wheels and a cheaper route, and did so in very clear understanding that by accepting that lower rate and that system of transportation, there was a limitation of liability at zero. And it was clearly written in the contract, and it was referred to the legislation, and it's a specific article which allows parties to agree outside to allow them to limit liability. And the parties signed saying, we agree, limited liability, zero liability. The rate is subject to zero liability. CN also published a special tariff for this movement, and at the rate, which is $2,083, and in that tariff specified zero liability and the requirement to sign a contract between the parties. So in terms of the intention of the parties, it was absolutely clear that the shipper knew that the liability, that the responsibility of CN in the case of loss or damage was zero. It turned out that the train consist was pushed in the Tétrault yard. The 2 cars were in the middle of a bigger consist, and 2 of the 2 cars in question derailed, and $600,000 worth of damage was caused to the shipment. It turned out in the first instance that instructions to set the cars only at the rear of the train were not followed because they were in the middle, and there was a little bit of confusion about how the accident happened and who was entirely responsible. But and I'll come to that in just a moment. Bombardier claimed the value of the damage from its insurers, ACE, who paid the claim, and were subrogated in CN's claim were subrogated in the rights against CN. So the Superior Court in the first place looked at the matter, and Justice Courchain, asked the question, first of all, is the exclusion of the carrier's liability applicable to Bombardier or to its insurer? And 2, was CN negligent? So the court referred to Section 137 of the Canadian Transportation Act, which actually the language changed since between the incident and the judgment, but she referred to that section as it was written at the time of the incident and the time of the contract, and which specifically states that by written agreement signed by the shipper, the carrier may limit or restrict its liability for loss or damage, and in French, peut limiter sa responsabilité. So basically the court analyzed the language of this article in the Canadian Transportation Act and did not look elsewhere, but essentially came to the conclusion, looked at doctrine about limitation of liability and contract law in Quebec, and came to the conclusion that 137, when it says a carrier may limit or restrict its liability, that does not include excluding liability. And therefore, because it was a total exclusion, the clause was inapplicable, and CN was therefore liable for full liability. There was, as I said, there was an analysis of the facts, and there was, because there's a presumption that the carrier is liable because of an obligation of result, she applied that principle and found that CN, that the facts suggested that it was a fault of CN at the switching yard in Tétrault, and therefore found them liable for the damage. The court essentially was saying you can limit your liability, but you can't exclude it under 137.1. And they suggested that if the case had occurred after the change in 2015 to 137.1, then perhaps it could be different. CN disagreed with this decision and went to the Court of Appeal before a bench the judgment of whom was rendered by Justice Marie-Josée Hogg. The court reviewed the facts in the same situation, reviewed the law, and asked the question, can CN totally exclude liability when damage is a result of its fault? It analyzed the law and finds, contrary to the first justice who limited her analysis to 137.1, the court found that it was 126 that was the source of law which allowed the carriers to limit their liability. And 126 is the article which allows a carrier to enter into a confidential contract to set the terms and conditions of carriage. And it is fairly broad language, which it doesn't even mention limit liability. It just says set the conditions for the terms other than in a confidential contract. So if it doesn't, either a tariff applies, a published tariff, or the railway and the shipper can enter into a confidential contract, which can have, according to 126, and I'll read it. I'll read it to you. Excuse me a second. Move the slide. Excuse me. So 126, confidential contracts may include 126.1e, any conditions relating to the traffic to be moved, including any amount to be paid by the company or the shipper in relation to a failure to comply with any conditions related to the service obligations under 113. 113 is essentially the common carrier obligations to deliver. And so 126.1e, and CN argued that 126.1e was clearly a possibility for parties to come to an agreement to limit or, if necessary, exclude the amount to be paid. And their interpretation was to any condition, including any amount. The judge went and analyzed this question and essentially came to the conclusion that 126 was the source by which the company could limit its responsibility, but could not exclude it. So the court interprets 126 to allow it to limit its responsibility in the case of fault in a confidential contract, but does not allow the exclusion of all liability. To do so would be to distort the contract of carriage, but because the principal obligation is to deliver the goods in good condition, and and such a clause would render it to be optional for the carrier to potestative a clause that would be basically one party has an obligation and the other party can choose to exercise this obligation or not. And that was the logic by which Justice Marie-Josée Hogg decided that 126 did not extend to allow the railway to choose to execute the contract or not. And that's how she interpreted it. Now, and I'll come back to that in just a moment because it's an interesting analysis. So the clause in the contract cannot, and according to her in law, it is not possible to have a clause where the stipulating party has the option of executing or not its obligation, and referred to that as an abusive clause. So when is one the new zero? CN argued that it had entered into a maximum liability, if it had entered into a maximum liability of $1. I'll change my slide. I'm not change my slide. If it had entered into a contract, and instead of writing zero liability, it wrote one, then that would be they would have met the conditions, and therefore it's a nonsense to apply that. The court disagreed completely and said if it was $1, it would also be illegal because $1 and $0 is equally illegal. So, and finally, the court stated that unless the law clearly allows such a thing, a clause excluding all liability will be null and inapplicable. So I'm just drawing to the end of my presentation, but before doing so, I will set out a few questions which I think are interesting to consider. And I'll just take 1 minute to do it, if I may. So the question, does 26(1) of the Canadian Transportation Act specifically exclude two sophisticated multinational transportation companies from agreeing to exclude liability in the case of loss or damage? It says you can write a contract and you can set the terms of the amount payable in case one party doesn't deliver or it causes damage. Does potestative or optional clause apply here, whereas the judge says it qualifies it as basically the carrier's option to fulfill the obligation? I would ask the question, if the carrier had chosen to damage the goods, if it had been done on purpose, it would be gross negligence or faute lourde, which would automatically nullify any restriction, and it would not be, and in this case, it was not applicable at all. So it was not a choice by CN to cause damage, it was an accident, and they are responsible for the accident. Finally, is the liability limit defined in the regulation? And if the parties wish to modify that, will 126, does 126 allow it? It certainly appears that it does. And even in 2034 of the Quebec Civil Code specifically mentions that a carrier may exclude or limit its liability or may not, except to the extent and subject conditions established by law. So the notion of the impossibility for a carrier to exclude liability, there are certain questions. This is what this judgment says, but there's certainly questions that are raised to that may be brought that into question. I guess lastly, will the fact that there was a change in the legislation in 2015, will that change the outcome? The fact that she based the decision on 126 would suggest that perhaps not. That will be left to courts and further people to discuss in the future. So thank you very much for your attention, and I will pass this over to Brian Lipson, if I can.
Yeah, thank you, David. While Brian is sharing his screen with us, I just want to thank David for his very good presentation. I appreciated certainly the background info on the cases that led to the determination of how the liability is considered. That was very interesting. And the list of questions, which there are many that still remain to be answered based on future cases. So thank you very much, David, for that. Brian, if you're ready, please proceed.
Yes, thanks, Eric. Thank you very much, David, for the presentation, and thanks to everybody for coming and for CILTNA for having us. I understand that there are people from a huge number of countries here today, and so welcome to all of you. As obviously this is a seminar regarding Canadian law, and I hope it's interesting for whatever jurisdiction you are operating or practicing in. And welcome also to the students that are with us today. I'm going to be discussing another decision, ABB Inc. and Canadian National Railway, a federal court decision from last year. The takeaways in terms of the holding of the case in this decision are that the court said that a limitation of liability must be in a confidential contract signed by the shipper, that claims between the shipper and any subsequent carrier. So you'll see that in this case, the original carrier passed off the load to a second railway, are going to be decided according to the governing law of the first contract between the shipper and the initial carrier. And then the court will say that in Quebec, this is actually a contractual relationship. It's deemed to be contractual. And that the originating carrier will have vicarious liability for loss or damage that occurs while the goods are in the care of a subsequent carrier. The other thing that the court says here is that the prohibition on zero liability, on excluding liability that David just mentioned, may not apply where there's a two-tier provision that deals with negligence. I'll get to that in more detail in a moment. So the facts of this case, ABB is a Swedish company with the headquarters in Canada in Varennes, Quebec, that you see here. And ABB had a transformer called an X-former that it needed to ship to a Tennessee Valley Authority plant in Drakesboro, Kentucky. The TVA, as you might know, was part of the New Deal. Here's FDR signing the TVA Act in 1933. The TVA was a part of the New Deal, it ended up being a power company. And incidentally, this plant in Kentucky was shut down last year, early on in the pandemic. So ABB has this transformer that it concludes an agreement with the CN with headquarters in Montreal, and it tenders the load to CN in the first for the first leg of the journey. CN takes the load and then hands off the load to a second carrier, CSX Transportation, for the move to destination in the United States. And at this point, I'll let my 10-year-old daughter Stella explain what happened on the journey.
Shortly before reaching destination, the transformer hit a bridge and was severely damaged. CN and CSX both denied responsibility. According to the decision, CN argued that it delivered the transformer to ABB in good condition, and CSX argued that it had no contractual relationship with ABB.
So whoever wrote the script for Stella should have said that CN claimed that it tendered the load to CSX in good condition, to the second carrier, and therefore couldn't be liable for any loss or damage. But that basically sets out the argument and what happened in the trip. So there was loss, there was damage in the amount of around 1.5 million was the agreed amount of damages. The judgment splits up the issue into two claims, basically the claim between ABB and CN, and then the claim between ABB and CSX, and I'll take them one by one. So as this nice man is explaining to his friend in a bar, there was, in the first place, an agreement between ABB and CN, whereby CN's agreement, liability for dimensional loads, like the transformer of ABB, was limited to $25,000 unless negligence was proven. And it did not say whose negligence, and this contract renewed indefinitely. And you'll now see the same couple after 1 year of being kept home due to a pandemic. And now she's explaining to him that in 2015, then there was a tariff issued from CN to ABB that said that the rate includes limited liability coverage of $25,000 while handled by any carrier in the route without any reference to negligence. And that will be crucial in the judge's determination of how this all shakes out. The first thing that the court says is, reminds everyone of 137.1, that any limitation, anything dealing with liability must be signed by the shipper, and that where there is no agreement, apart from cases where there's an application to the agency, which normally does not happen, then the liability regime will be as set out in the railway traffic liability regulations. Then the regulations at Section 8, and again, we're dealing with CN's liability toward ABB, enacts a vicarious liability scheme such that the originating carrier will be liable for loss or damage. And again, this is in the absence of an agreement. So basically, CN's arguments in federal court were that, first of all, the 2015 tariff, which has a limitation that doesn't count on there not being negligence, superseded the 2011 signed agreement that has a limitation except in cases of negligence. So CN's idea is that the limitation would apply even where any negligence is proven. And the federal court is not in agreement with that. It says that the 2011 agreement remains in force, is not superseded, and that the 2015 tariff is not signed. It doesn't comply with 137 of the CTA. And so if any negligence is proven, then there will be no limitation of liability in this case. CN also argued that the agreement between the parties totally excludes the application of the regulations, because at 137.2 of the Act, it says if there is no agreement, and then it goes on to say that the liability will be dealt with as per the regulations. And CN's argument was that there is an agreement, and so this shouldn't apply. The court was did not agree and said that Section 8 of the regulations remains applicable and is suppletive to the parties' agreement. So the court's reasoning is that CN is therefore going to be liable if there is any negligence. The court goes on to determine that CSX was negligent down the line in its execution of the contract, and that CN is liable for the loss that occurred while CSX had the load. The court then asked the parties, after the ACE decision came out, it asked the parties to weigh in on the application of that decision. And what the court said here was, no, that exclusion does not apply. That issue does not apply here. And the reason is that the 2011 agreement that applies to, that limits liability where there is no negligence, it does not totally exclude liability. So if you have, the idea in this judgment is that ACE will not apply where liability is zero except in cases of negligence, or 25,000 in cases of negligence. And you know, the obvious implied idea is that is 25,000 as close to zero as $1 is in the decision. And so that's you know, the space between zero and whatever number the parties, you know, that's an argument for another day, obviously, in light of the ACE decision. But I thought it significant that this court said that if you have a two-tier liability regime, then ACE doesn't apply. So moving on to the ABB versus CSX claim in this same decision, one thing you might wonder is what law would apply? Is it Quebec law where the agreement between ABB and CN was entered into? Is it Jacksonville, Florida, where CSX is headquartered? Is it Drakesboro, Kentucky, where the destination is? Or is it TVA's headquarters in Tennessee? The court, for a couple of reasons, decided that, surprisingly, Quebec is the governing law of the claim. One reason was there was some reference to a well-known book about motor carrier cargo claims that points out that, you know, under federal trucking law, the provincial law at the origin of the shipment normally applies. And there was also discussion of Section 8 of the regulations. Now that the court has decided that Quebec law applies, it's therefore the Civil Code of Quebec that applies. And two provisions in particular were used by the court. One saying that any second or subsequent carrier is deemed to be a party to the initial agreement between the shipper and the originating carrier. So CSX is actually a contractual party to ABB and CN's contract and all of the terms in it, according to the court. And then the other being that a shipper can make a claim against its actual contractual counterparty or the last carrier who delivers the load. And that's worth contrasting with Section 8 of the federal regulations, which allows a shipper to bring an action against any carrier in the chain. So what the federal court says is by accepting the load, CSX becomes a party to the contract that CN had with ABB. And that one contract contained a limitation of liability, again, according to the court, that only applied where there's no negligence. And so the court's reasoning is that now that CSX is a party to this agreement, if there's negligence, then CSX cannot rely on the limitation of liability, just like CN couldn't in its vicarious liability for the loss that occurred while CSX had the care, custody, and control of the load. And then what the court does is, since the court had already decided there was negligence on CSX's part, so the court held CSX and CN solidarily, which is the civil law version of jointly and severally, liable to ABB for the entire loss. The case is now before the Federal Court of Appeal, and we're all obviously looking forward to seeing that. We don't know what's going to happen here. What we can do is provide some recommendations if this judgment is upheld on appeal. So in a world where not only the ACE decision, but also this ABB v. CN decision becomes the applicable law in Canada, what can we recommend? First of all, it would be clear that any limitation of liability needs to be signed by the shipper. Now, what does sign mean? We're comfortable saying that DocuSign or electronic signatures are signed by the shipper. Is signed by the shipper also an email confirming a tariff? Is it saying okay in a text message? These are all questions that would come up as this question becomes more and more focused upon by parties who are increasingly needing to either enforce or avoid limitations of liability in contracts. To the extent that applicable law is intended to be excluded from a commercial agreement, it's important to do so. So since the federal court judge in this case said that Section 8 of the regulations is suppletive to the agreement. If the parties want to exclude any such provision, they'll have to do it expressly. And as I mentioned, in order to avoid the application of the ACE decision, you'll want to carve out negligence from any limitation of liability. So this is a way of making sure that there's no exclusion and that the court looks at it properly as a limitation. For any downstream carriers, the issues are, in my view, threefold. So for the shipper, you want to make sure that you retain your claim against not only the originating carrier that you're contracting with directly, but also any downstream carriers. And that can be done by avoiding any limitation from the initial carrier that would exclude that ability to claim from them. If you're the originating carrier, you want to make sure that you are not responsible for any liability in respect of damage or loss that occurs downstream from you. And if you're a delivering carrier, well, not only do you need to be very careful with the terms that you enter into with the carrier that's tendering the load to you, but also this judgment implies almost a due diligence style operation to determine what the terms were of the initial contract between the shipper and the first carrier, so that you can make sure that you know exactly what you're getting into. Because as we see, if a court decides that, for instance, Quebec law applies, then you're going to be deemed to a party to that initial agreement. And there is some support in common law for the proposition that a downstream carrier will be party, not necessarily in the language of party to the agreement, but that its limitation of liability would be in the same terms as the bill of lading, even where there's not a through bill of lading. So what can we recommend as far as contractual language in this kind of climate? Should this decision hold up? You'll have to forgive me because the person who's pictured here assisted me in the value of the provision. But basically, what this provision does, and I won't read it, but what it does is three things. First of all, you limit liability to a certain amount if there's no negligence. You limit liability to another amount if there is negligence, and make sure that you say that the negligence of that carrier is what we're talking about, the initial carrier, not any carrier. And then that you exclude any applicable law you don't want, and you exclude any downstream liability. So this is sort of an example provision from the standpoint of CN in the ABB case that would work to overcome the issues in that case, and also avoid potentially the application of the ACE decision. So this case and the ACE case taken together, if they both hold up, it would really change the way that parties are able to commercially agree. As David explained early on, it's not a matter of carriers and trying to get out of liability and shippers trying to hold them to. It's what's at stake here really is the ability for two sophisticated commercial parties to come to an agreement as to allocation of risk, and also to allow carriers to give some of that risk to the shipper in exchange for a lower rate. And so the economic and legal implications of these decisions are quite important. And we're, as I said, really looking forward to seeing what the Federal Court of Appeal and possibly the Supreme Court of Canada say in the ABB matter to give us a sense of what we're dealing with going forward. Thanks very much.
Thank you, Brian and Stella, for this very interesting presentation. We now have a few questions from the group, and I'd like to put those to our speakers. First of all, there's one question from Liz, who's essentially asking, what's the trigger for a rail carrier to become a common carrier with the associated obligations? Are all railways common carriers? So I don't know. I think it was asked during David's presentation. Maybe David, if you could proceed with an answer here.
Yes, I would suggest that all public railways are common carriers. and they are under the common law, and they are under the federal regulation. So and if all federal railways are, in fact, I'll turn my video on there. All federal railways are subject to holding a certificate of fitness issued by the Canadian Transportation Agency, and therefore they are a defined entity of a federal railway, and they're necessarily a common carrier.
Okay, all right. Thank you, David, for that. Now, I must say that there are many questions around, of course, what I would call maybe the number that would be in the eyes of the decision of the Federal Court of Appeal. What's the number? If 1 is equal to 0, then how do you go at establishing a value that becomes acceptable? Based, of course, on the principles and the provisions interpreted by the court.
Would you like me to answer that, Eric? Yeah. If you can, yes. Essentially, the court, it's unclear. The court says that unless it's specifically permitted by the legislator, you can't do it. And then it says to allow a carrier to disculp itself in advance from all responsibility in the eventuality of its fault, it doesn't succeed because it would, as I said, it would take away the principal object of the contract, and then it specifically makes a limitation to $1 in this context would be the equivalent of 0, and it's not because a carrier has stipulated that it's 0 that he can always maintain that it would apply, and it says I estimate that in this matter the circumstances and proportions that will have to be considered to evaluate the situation. So it's really very unclear. The answer, I should be saying, it's very unclear.
And would you agree that, given the change to the wording of Section 137, that this entire discussion may in fact vary or change, considering that the words that led the judge to conclude that a total exclusion was not possible have been removed by Parliament?
It's a very interesting question, and I've been thinking about it a lot. The way the judgment is written, and the way and Justice Hogg specifically refers to Article 126 and the interpretation of 126, and there's actually an error in the language, but it's almost as if she was referring to 137, but she's not. She says 126, and so her position is that 126 is the foundation of the possibility of a carrier limiting its liability, and that foundation does not extend to the exclusion of liability. So and 126 wasn't changed. It was 137 that was changed. But again, the logic, I think, is there are people that can question that logic because of the fact of it's a confidential contract, which, if you read 126, allows the parties to decide exactly what they want. So it's going to be interesting how it develops in the future in terms of jurisprudence.
Right. Yeah. I mean, thanks for sharing your views on this. I'd like to make a short, brief comment. I'm from CN, and of course, CN is a proud carrier. And even though there's been discussions here about cases involving incidents, with CN, I want to stress that CN is a reliable carrier, and that our safety record last year showed significant improvements relative to last year. Carrying on now on more questions. A question from Ray G. There was a comment that common carriers cannot refuse service. Surely there must be some limitations to this. To what extent will courts interfere with parties' freedom to contract? That one is interesting, I believe, because it's basically at the center of this discussion, which is limitations of liability is part of the negotiated items when a transportation contract is made. So What's your take on that? Maybe Brian, if you want to go ahead.
Sure. Well, the way it works is you're indeed required to pick up as a carrier, you are required to provide service subject to payment of the applicable lawful rate. Basically, the way it works is it's a trade-off. So the two ways that it can go, and it's described in both of these judgments, is one way is that the railway publishes a tariff and says, this is my rate for the shipment, and then the shipper can either take it or not. But when the shipper takes it, it's basically, contractually speaking, it's an offer to the public to contract, and if the shipper accepts that offer, there's a contract. The other way to do it is a confidential contract, that there's a negotiated rate and negotiated terms of liability, perhaps. And that's where the negotiation can come in. So yes, you're required, but typically you're required to provide service, but you dictate the terms of that contract. And so the trade-off is where there can be negotiation in terms of the confidential side.
Okay, thank you. We've got Marion Robson asking, what's the substance of the change in section 137? Which one of you want to take this?
I can address it if you like.
Sure.
137 used to say, and if you look at the language of the judgment, it says a railway company shall not limit or restrict its liability to a shipper for the movement of traffic except by means of a written agreement signed by the shipper or by an association. And so that's what the judge of the first instance considered in great detail. Subsequently, the Canadian Transportation Act, now in 2015, basically the whole of 137 was redone, and so the structure of 137 has so 137.2 specifically now says, if there is no agreement, the railway company's liability to the shipper in respect of loss or damage to a shipper's traffic shall be dealt with between the company and the shipper. And then it says if there is no applicable, or if there's an application but the agency does not specify any terms, then it's dealt with in the manner set out in the regulation. So essentially 137 now says that unless there's an agreement with the shipper, it is dealt with according to the regulations. And right. 126 still says it can't be limited unless it's signed by the shipper.
Right. I guess though, I think certainly 137 appears to suggest that there's a recognition of the freedom to contract. I mean, we must remember that this is a commercial environment. We've got two parties, commercial parties, typically sophisticated, negotiating those things, those provisions. And the sense I have is that 137 is kind of recognizing this by saying, well, by agreement, this can be done. Now that said, that remains to be the extent of this remains to be determined by future decision. But certainly, it's a change that I think will provide some light in the future about this issue.
Eric, I just want to add, and this goes into a question that Ian just asked in the chat. Once you've decided that Quebec law applies to the contractual relationship between the parties, and once you've decided that this civil law notion of obligation potestative is going to apply such that any optional obligation on the part of the debtor of the obligation would not be a legitimate contract, it doesn't matter what 137 says exactly. Once you have this determination that the civil law applies, and if there's no there in the agreement, then it might be the Quebec court's view of this, or any judge applying Quebec civil law to this kind of issue might be the same solution going forward.
Right. I guess the way I understand this issue is that the provincial civil law comes in to supplement what the federal framework is not governing. And I guess here, I think to Ian's question, I believe that the very first issue will be whether or not 137, by providing by contract that this can be, that the matter can be dealt with, the question will be whether or not the federal provision is occupying the field to the point that there's no need to refer to superlative provincial legislation. And that will be, I think, the way that this discussion will be framed and take place.
And then what the court did is when it was time to decide which provincial law applied, it relied on section 8.1 of the Interpretation Act, the federal interpretation Act, to say, there's nothing saying that it would be more likely to be common law than Quebec law. And so it was open to the court, in the court's view, it was open to the court to say, well, it's Quebec law because of what they decided that the contract was entered into it in that province and so on. But, common law contract law typically applies, or civil law contract law typically will apply to a federally governed railway claim. It just depends which one.
Right.
And the federal act, when the civil code refers to, you can't restrict or limit your liability, you can't exclude or limit your liability unless authorized by law. That law does include the federal act and the federal regulation, which allows you to limit your liability. So it can be done. And I think it's important to note, to pick up from what Brian said, that going forward, make sure that the contracts specify which body of law you want to apply and which you don't want to apply. And so if you're contracting in Quebec and you don't want the civil code to apply, make sure you write it down in your contract.
Okay, thank you. Maybe before concluding, I would have a general question. We've got, I think, more than 15% of our attendees are students. And David and Brian, if you if you had a piece of advice to those students who are either studying law or interested in doing so, what would be your advice to them?
Wow. If I may jump in, I would say that the topic of transportation and logistics it's one of the most important features of modern economy. Everything in the modern economy depends upon transportation and logistics, and the law of transportation and logistics is absolutely fascinating. And so when you read the title of this paper, you probably thought how boring, but when you listen to all the issues, it's absolutely fascinating. And so we need young blood to come in and take this case law further and find new and better solutions to how to apply the law going forward. So I encourage you to join our profession, and I should say the profession. I encourage you to enter into the world of transportation logistics. It's a fascinating place to be.
All right. Thank you very much for those comments, David. Thanks to both of you for those very interesting presentations, and also thank to Marsh, our sponsor for this conference. I want to encourage everyone to check out the CILTNA website. It's at ciltna.com to see details on the next webinar. Importantly, please consider joining us at the CILTNA. This association provides opportunities to learn and be involved in a sector that is directly connected to trade in the world in support of the economy. Join us if you have an interest. Reminder, you'll be getting a survey. Please fill it and provide your comments. That's important to improve what we do those conferences. Thank you everyone for attending. This concludes this conference.